Good day, class. So last meeting, we have already finished discussing the first paragraph of section 5 of Rule 110. And I also showed you a sample authority to prosecute last meeting, although we got cut off because of the internet connection. So I'm showing this again. So basically, we have here the caption of the case. We have here the court where the case is actually lodged, and then the caption of the case, People of the Philippines versus the accused, as this is a criminal case, the title of the case and the criminal case number. And then it would now contain the authority given by the prosecutor, the public prosecutor in the case, citing, of course, the provision in Section 5. So basically, this is how an authority to prosecute looks like, just for you to have an idea. No? Now, let's proceed to the intervention of the offended party in prosecution of criminal cases. So, when can an offended party intervene in the prosecution of the criminal action? Remember that it is a fundamental principle in criminal law that every person criminally liable for a felony is also civilly liable. You will come across this in your criminal law 1, particularly in Article 100 of the revised penal code, wherein if a person will be held criminally liable, it also goes along with it his civil liability. Okay? This underlying this principle is the traditional theory that when a person commits a crime, he basically offends two entities, okay? Dili lang ang state, not only the society in which he lives in or the political entity called the state, whose law he has violated, but also the individual member of that society whose person, whose right, whose honor, chastity, or property was actually or directly injured or damaged by the same punishable act or omission. The civil liability in this case, friends, would actually include, inyo sa ding makita no, in your criminal law, in the revised penal code, particularly in your Article 104, this would include restitution. Okay, basically restitution is like the restoration of the thing. Reparation of the damage caused. Here, the court would actually determine the amount of the damage, and the court here would take into consideration the price of the thing and also its sentimental value. And then we also have the indemnification of consequential damages. These are actually damages on the part of the injured and the family and the third party by reason of the crime. So accordingly, the sole purpose of civil action is for restitution, reparation, or indemnification of the private offended party for the damage or injury he sustained by reason of the felonious act of the accused. Except when the civil liability is extinguished, the offender shall be obliged to satisfy the civil liability resulting from the crime committed by him, even if he has already served his sentence, consisting of the privation of liberty or other rights, or has not been required to serve the same by reason of amnesty, pardon, commutation of sentence, or any other reasons. So regardless of the fact that the accused has already served his sentence or has been pardoned or sentence be commuted, or maybe he's been given an amnesty, still the accused here has to satisfy his civil liability when he is found guilty for the commission of an offense charged against him. Okay? Now, how can the offended party intervene in a criminal case? Well, the appointment of a private prosecutor is done by the offended party and is the mode by which he can intervene in the prosecution of the offense. The intervention is, however, only allowed where the civil action for the recovery of the civil liability from the offense charge is instituted in the criminal action pursuant to Rule 111, which we will discuss later after Rule 110. So basically, you can only intervene with respect to the the offense to the prosecutor if you have not waived, or if your civil liability is that of arising from the offense charge as instituted under Rule 111. So if you include the civil liability arising from the offense charge, you can always do so by intervening through a private prosecutor. So remember that the offended party may not intervene in the prosecution of the offense through a private prosecutor if the offended party waives the civil action, kung iyang giwaive. Next, if he reserves the right to institute it separately, because you can always institute it separately, the civil liability. And if he institutes the civil action prior to the criminal action. The reason is that there is no civil liability which would supply a basis for the intervention of the offended party through his counsel or private prosecutor. So the presence of a private prosecutor in the criminal action may be objected to by the accused, right? Now let's continue our discussion with Section 5 of Rule 110. Okay, Section 5, the second paragraph of Section 5, Rule 110 provides that the crimes of adultery and concubinage shall not be prosecuted except upon a complaint filed by the offended spouse. The offended party cannot institute criminal prosecution without including the guilty parties. Okay, remember that. If both alive, nor in any case if the offended party has consented to the offense or pardoned the offenders. Okay? Again, the offended party cannot institute criminal prosecution without including the guilty parties if both alive, nor in any case if the offended party has consented to the offense or pardoned the offenders. The offenses of seduction, abduction, and acts of lasciviousness shall not be prosecuted except upon a complaint filed by the offended party or her parents, grandparents, or guardian, nor in any case if the offender has been expressly pardoned by any of them. If the offended party dies or becomes incapacitated before she can file the complaint, and she has no known parents, grandparents, or guardian, the state shall initiate the criminal action on her behalf. The offended party, even if a minor, has the right to initiate the prosecution of the offenses of seduction, abduction, and acts of lasciviousness independently of her parents, grandparents, or guardian, unless she is incompetent or incapable of doing so. When the offended party, who is a minor, fails to file a complaint, her parents, guardians, grandparents, or guardian may file the same. The right to file the action granted to parents, grandparents, or guardian shall be exclusive of all other persons and shall be exercised successively successively in the order herein provided, except as stated in the preceding paragraph. And then the next paragraph, no criminal action for defamation which contains in the imputation of the offenses mentioned above shall be brought except at the instance of and upon complaint filed by the offended party. The prosecution for violation of special law shall be governed by the provisions thereof. So regarding, because this is basically prosecution for the crimes against chastity, no? Especially in seduction, abduction, and acts of lasciviousness. This is basically stated in similar provisions in the revised penal code, particularly in Articles 344 and 360. With respect to the crime of rape, however, there has been a major substantive change necessarily affecting the procedural rules in the prosecution thereof. Because on September 3, 1997, Congress actually enacted RA 8353, or the Anti-Rape Law of 1997, which reclassified rape under the crimes against persons. Okay? In your book 2 of your criminal law, in your criminal law 2, you will learn later on that crimes are actually classified into different books, okay, or into different titles. So you will see there that there's crimes against persons, crimes against honor, crimes against chastity, crimes against property, crimes against law of the nation. So basically, enumerate sa revised penal code, particularly in book 2, kung unsang mga crimes against honor, crimes against chastity, crimes against persons, nga na. Before, ang rape was actually classified in the crimes against chastity. Okay? But because of the amendment in September 3, 1997 of RA A353 or the anti-rape law, si anti-rape law was already reclassified in or as a crime against person. So ano siya na-appeal diri sa enumeration in Rule 110, Section 5. Okay? So the amendment or the mandatory act having consequently eliminated rape from the enumeration of crimes against chastity, which was the basis to the corresponding provision of this section, Section 5, regarding their prosecution. The logical result is that the crime of rape can now be prosecuted without a sworn written complaint of the persons consecutively named in the said section. So basically, kaning mga crimes enumerated in Section 5 of Rule 110 are crimes which cannot be prosecuted de officio. Crimes which cannot be prosecuted de officio. Pasabot nga only upon the instance of the private offended party ma-institute ning kasuha. Okay, because these are private crimes. So let's continue. Remember that the crimes of adultery and concubinage shall not be prosecuted except upon a complaint filed by the offended spouse. The rule here is clear. So the rule is clear. The prosecutor cannot prosecute the case where no complaint is filed by the offended party, okay? It should be the offended spouse who should file the complaint. So kung si Juana, ang asawa, would commit adultery with a married man named Pedro, ang asawa ni Pedro cannot prosecute Juana for adultery because dili man siya ang offended party. So the one who should actually file the complaint for adultery should be Juan, the husband of Juana. Remember how when we say adultery, it is actually the wife who actually commits the the illicit affairs. When we talk about concubinage, it is the husband who commits the same. Okay? So kung mayong kag-adultery, in this case, kung si Juana ang nakasa, it shouldn't be the wife of Pedro nga kabit ni Juana ang mo-file og adultery, but the husband of Juana ang mo-file og adultery. Okay? The erring spouse cannot, as a rule, be prosecuted upon an information filed by the prosecutor. The offense should be prosecuted upon a complaint filed in court by the offended spouse. It should be the offended spouse who shall prosecute the case against these offenses enumerated in Section 5, particularly in the crimes of concubinage and adultery. The same rule also provides that this action cannot be instituted against one party alone, okay? It must be instituted against both guilty parties unless one of them is no longer alive. Dapat silang duha ang ikiha unless patay ng usa, okay? In the example given, ganihan ako kung si Juana or kung si Juan files a complaint for adultery, si Pedro nga kabit ni Juana, i-appeal gid na. He must be impleaded if both of them are actually alive. Okay? Now let's try to examine the case of People versus Elarde. Okay? This is actually a petition for review on certiorari of the order of the Regional Trial Court of Iloilo, presided by the respondent judge Elarde, granting the motion to quash the information in criminal case number 13086, entitled People of the Philippines versus Santibanez and Javillana. Okay? Kaning kasuha was actually filed in 1981. Okay? Nya, ang information reads as follows. Ingon dire, the undersigned city fiscal, upon sworn complaint originally filed by the offended party Efraim Santibanez, copies of which are thereto attached as annexes A and B, hereby accuse Cecil Santibanez and Abilino Javillana of the crime of adultery committed as follows: that on or about 3rd day of November 1980 in the city of Iloilo, Philippines, and within the jurisdiction of this court, said accused Cecil Santibanez being lawfully married to Efraim Santibanez, which marriage at that time has not been legally dissolved with deliberate intent, did then and there willfully, maliciously, and criminally have sexual intercourse with her co-accused Lino Javillana, a man not his husband, and who in turn, knowing fully well that his co-accused was then lawfully married to Efraim Santibanez, did then and there willfully, maliciously, and criminally have sexual intercourse with her contrary to law. Annex A referred to in the information is a sworn complaint for adultery filed by Efraim Santibanez against her in private respondents Cecil and Avellino with the Integrated National Police of Iloilo Metro Police District of Iloilo City in November 4, 1980, which complaint was immediately forwarded to the Office of the City Fiscal for preliminary investigation. Yang Annex B sa information kay ang affidavit complaint, this time dated November 6, 1980, executed also by Efraim Santibanez, nya gifile pod sa City Fiscal on November 7, 1980, wherein Santibanez recounted in detail the antecedents which brought about the apprehension in flagrante of private respondents. And the same was quoted as follows. Mauni ang naa sa iyahang complaint affidavit siya ay Efraim Santibanez, of legal age, married, and a resident of Fundidor Molo, Iloilo City, after having been duly sworn to in accordance with the law, hereby depose and say that I am legally married to Cecil Soriano in a civil marriage solemnized by Judge Vicente Santos of City Court of Pasay on March 22, 1974, but subsequently remarried in a religious ceremony before Reverend Father Panfilo Brazil at the Parish Church of La Paz, Iloilo City. Pag 1974 sa daw. So iyang gi-attach ang iyahang marriage contracts as annexes A and B of the said affidavit complaint. After our marriage, ingon si Efraim, after our marriage, I built a house for our permanent residence and as our conjugal home in Fundidor, Molo, Iloilo City, and furnish it with all the comforts well within my means. At the start of our marriage, I was led to believe that my wife, of her total concern, love, and devotion to me, valid in turn, I lavish her with all the material comfort at my command, and even tried to build up her social status by sending her a delegate to the Junta World Conference at Washington, D.C. last July 1980 without any company. As a token of my love and unfailing trust, we went sightseeing and on second honeymoon to Hong Kong only last month. Inana niya kapinangga kuno iyang asawa. Karon iya pag yung gisumpayan, sometime during the last week of October 1980, while I went on my normal work routine to Pasi Sugar Mill site in Pasi, Iloilo, my son Edmond took me aside in confidence and told me that he has some very delicate matters to take up with, which may be misinterpreted by me and may be taken by her in wrong light. However, he said that his valid dignity of the family is at mistake and I have to know it whatever be the consequence. Nindot siya language, no? After I gave him the go signal, he narrated to her that my wife, Cecil Soriano, has been unfaithful to me and has been having illicit relationship with another man. Of course, I was taken aback and stunned, so I asked him for the source of his information. He informed me that our maid Elsa Barrios and our driver Loreto Reales had been aware of the relationship, and the man usually went to my house and even slept there whenever I was in Manila. I got angry and blamed our maid and the driver for not telling me, but Edmond told me that they were afraid to tell because they were threatened. After I have come down, I commended that if I confront my wife about her illicit relationship, she will surely deny it. So I thought that the best way was to catch her red handed in the act of infidelity so that she could not deny it anymore. I suggested to Edmond to take or to think of a plan so we can catch my wife red handed. After several days of planning, we agreed to put our plan in action. On November 3, 1980, since I will be leaving for Manila in the morning of that day. Our problem was how to catch my wife in the very act of having sexual intercourse with her lover, considering the fact that our master's room was air conditioned, with all windows framed by glass jalousies, closed and covered by curtains. At first, we thought of breaking down the main door with a sledgehammer so we could take them by surprise. Later, we abandoned the idea because of legal complications. Finally, I thought of removing a glass of jealousy so the inside of the bedroom can be seen from the outside. Once the curtain can be brushed aside by means of a thin wire, and the persons on bed could be seen clearly since the bed is on the same level as the opening of the window. After several experiments, whenever my wife was out, I found out that my wife cannot notice the removal of the glass jealousy since our windows are screened from the inside of our room. As prearranged, I removed one jealousy glass of the window of our master room so that the people inside our room could be seen actually from the outside. And the moment my wife and her lover is seen in the act of sexual intercourse. Yan, napag-isumpay ang affidavit siya. Having completed all the plans to effect our plan of operation, I told my wife that I will fly for Manila on that day. I instructed my son Edmond to inform me immediately of the result of the plan of action as soon as possible. Almost midnight of November 3, 1980, I was informed by my daughter-in-law, Rebecca, that the operation was successful and resulted in the arrest of my wife and attorney Bob Havillana inside our bedroom. Attorney ha? Attorney ang kabit, guys. I know attorney Bob Havillana for quite a time, and we have been close friends. As a friend, he has come to our house at Molo, Iloilo City oftentimes to discuss matters about the court case between the Iloilo City government and St. Therese Memorial Chapel, which is a business which I have been given to my wife, Cecile. Attorney Havillana knew that Cecile Sorianosos is my legally married wife. When I returned to Iloilo City from Manila on November 4, 1980, I was shown the photographs taken inside our master bedroom, and I am attaching here to the photographs, which are marked as annexes C, D, E, etc., etc. That I am formally charging my wife, Cecile Sorianosos, and attorney Bob Havillana of the complaint against them. So, mona ang iyahang complaint affidavit. So sometime in January 1981, before the conclusion of the preliminary investigation then being conducted by the fiscal's office, si Ephraim learned that he was sick of cancer and decided to leave for the United States for medical treatment. Before his departure, he executed a holographic will. Kanang holographic will, guys, mo nang last will. Pero only in the handwriting of the executor or of the person who executed it. So in this case, handwritten nga will ba, mo nang holographic will. So ningon siya dito sa iyang holographic will, I do hereby disinherit my second wife, Cecile Sorianosos, of any and all inheritance she is entitled under the law as my wife on the ground that she had given cause for legal separation by committing acts of adultery with attorney Bob Havillana in the evening of November 3, 1980 in my conjugal abode at Candido Subdivision, and as a result of which I charged her and attorney Bob Havillana for adultery with the fiscal's office, and I filed a case of legal separation against her in civil case number SP 11-309 of the Juvenile and Domestic Relations Court in Iloilo City for which act of infidelity, and I can never forgive her. Muna iyang gibutang sa iyang holographic will. So pag January 15, 1981, after several requests for postponements, ang private respondents submitted their memorandum to the fiscal's office. And on February 19, 1981, Fiscal Galvez issued a resolution finding the existence of a prima facie case for adultery against private respondents. So, on February 26, 1981, si Fiscal Galvez was informed by the relatives of Efraim Santibanez that Efraim had already died in the United States on February 16, 1981. This notwithstanding, he prepared the information in question on March 3, 1981, and the following filed the same with the Court of First Instance of Iloilo. So, bisan pag namatay na si Efraim on February 16, 1961, which Fiscal Galvez only learned in February 26, 1981, pag March 3, 1981, gipreparar niya ang information. So, ang private correspondence here, silang Cecil o si Attorney Bob, filed a motion to quash the information on the ground that the court thou did not acquire jurisdiction over the offense charge, as the offended party had not filed the required complaint pursuant to the provisions of Article 344 of the Revised Penal Code and Rule 110 of the Rules of Court to the effect that the crimes of adultery and concubinage shall not be prosecuted except upon a complaint filed by the offended party. Okay? Finding merit in the position taken by the private respondents, si respondent Judge Dire granted the motion and dismissed the case. Dismiss ang case. So the city fiscal moved for reconsideration, but the same was denied. Mauna nga naabot ngayon kasuha sa Supreme Court. So unsa may issue diri? The issue here is whether or not there has been compliance with the requirement of Article 344 of the Revised Penal Code, reiterated in Section 4, now Section 5 of the Rule 110 of the Rules of Court, that the crimes of adultery and concubinage shall not be prosecuted except upon a complaint filed by the offended party. So, nakabasa naman mo ng kasuha. How did the Supreme Court rule on this issue? According to the Supreme Court, we rule in the affirmative. We are aware that in a long line of decisions, this court has maintained strict adherence to the requirement imposed by Article 344 of the Revised Penal Code. Niingon ng Supreme Court, it must be borne in mind, however, that this legal requirement was imposed out of consideration for the aggrieved party who might prefer to suffer the outrage in silence rather than go through the scandal of a public trial. Thus, the law leaves it to the option of the aggrieved spouse to seek judicial redress for the affront committed by the erring spouse. And this, to our mind, should be the overriding consideration in determining the issue of whether or not the condition precedent prescribed by the said Article 344 has been complied with. For needless to say, this court should be given or guided by the spirit rather than the letter of the law. In the case at bar, ngayon na Supreme Court, the desire of the offended party Efraim Santibanez to bring his wife and her alleged paramour to justice is only too evident. Such determination of purpose on his part is amply demonstrated in the dispatch by which he filed his complaint with the police. The strong and the unequivocal statement contained in the affidavit filed with the fiscal's office that, ningon siya, kuno nga I am formally charging my wife Cecil Sorianosos and Attorney Bob Javillano of the crime of adultery and would request that this affidavit be considered as a formal complaint against them. His filing of a complaint for legal separation against Cecil Santibanez with the local juvenile and domestic relations court, and finally in disinheriting his wife in his last will and testament dated January 10, 1981. Further, niyon ng Supreme Court, in quashing the information, respondent judge relied upon our decision in People v. Santos to the effect that a salaysay or sworn statement of the offended party, which prompted the fiscal to conduct the preliminary investigation and then to file an information in court, was not the complaint required by Article 344 of the Revised Penal Code. Ngayon, ang Supreme Court further nga, the ruling in Santos is not applicable to this case. In that case, ningon ng Supreme Court, katong sa Santos, the salaysay executed by complainant Bansuelo was not considered a complaint contemplated by Article 344 of the Revised Penal Code because it was a mere narration of how the crime of rape was committed against her. However, in the affidavit complaint daw submitted by Efraim, katong bana ning kasuha, the latter not only narrated the facts and circumstances constituting the crime of adultery, but he also explicitly and categorically charged private respondents with the said offense. Diba? Niingon siya ato nga, I am formally charging my wife and would request that this complaint affidavit be considered as a formal complaint against them. Further, the Supreme Court said that in Santos, kumparar gyud sa Supreme Court, kung mo nag-cite ng arguments because in Santos, this court noted that the information filed by Rizal, provincial fiscal, commenced with the statement, the undersigned fiscal accuses Mona. In the instant case down in Supreme Court, in this instant case, however, the information filed by the City Fiscal of Iloilo reads as follows. The undersigned City Fiscal, upon sworn statement originally filed by the offended party, or imagine how important it is to state that there is an institution of the criminal case by the private offended party. So, imo yung specify. Ngayon ang Supreme Court, klaro, gi-specify sa fiscal nga the undersigned City Fiscal, upon sworn statement originally filed by the offended party, Efraim Santibanez, ha? Undoubtedly, according to the Supreme Court, undoubtedly, the complaint affidavit filed by Santibanez contains all the elements of a valid complaint, as it states the names of the defendants, the designation of the offense by the statute, the acts of the omission complained of as constituting the offense, the name of the offending party, the approximate time of the commission of the offense, and the place wherein the offense was committed. What is more, the Supreme Court, what is more is that the said complaint affidavit was attached to the information as an integral part thereof and duly filed with the court. Okay, as held thou in the case of Fernandez versus Lantin, the filing in court of which affidavit or sworn statement of the offended party, if it contains the allegations required of a criminal complaint under Section 5, Rule 110 of the Rules of Court, constitutes as a sufficient compliance of the law. Okay? And further, in the Supreme Court, upon these premises, we cannot but conclude that the adultery charged against private complaint or private respondents is being prosecuted upon complaint by the offended party. So here, the petition was actually granted. And the court orders the RTC of Iloilo Branch 5 in criminal case number 13086 to set aside its decision of dismissing or quashing the information filed by the Fiscal of Iloilo City and directed the judge to proceed with the trial of the case on the merits. Okay? And then that's the second paragraph, no? The filing of concubinage and adultery. Remember, it should be upon the instance of the private offended party. And kung buhi ang duha ka akusado o respondent, imo gyud ang implead silang duha, ang asawa ug ang kabit o ang bana ug ang kabit. Okay? Next, now on the next paragraph, remember nga in the crimes of acts of lasciviousness, seduction, and abduction, it may be instituted. Wait, let me get back to this one. Okay, so remember that in the crimes of, again, the offense of adultery and concubinage may not be instituted if it is shown that the offended party has consented to the offense or has pardoned the offenders. Okay, kung ni-consenter siya or yung gipardon, dili na siya, or it can be a defense for an offense or for a case filed against the respondent or the one who actually allegedly committed the crimes of adultery or concubinage. Kaya pwede niyang mahimong dipinsa nga nangabit ko kay ni consenter akong bana. Nangabit ko because I was already, or di na ko ni makiha because I was already pardoned by my wife. Now, the crimes of seduction or acts of lasciviousness can be prosecuted exclusively and successively by any of the following persons in this order. Okay? Una, by the offended party or by the offended woman. So even if the offended woman is a minor, remember that she can validly file and subscribe to a sworn written complaint. So if the said offended woman is of legal age and not otherwise incapacitated, only she can file the complaint, okay? If the offended woman is a minor or is otherwise incapacitated and she refuses or fails to file the complaint, either of her parents, grandparents, or guardians in that successive order can file the complaint. Okay? So, timan ina ha, successive order meaning, kung dili mo file si offended party or kung incapacitated siya to file, it could be the parents. Kung why parents, grandparents, kung why grandparents, iyahang guardians. Okay? In that successive order. Now, if it's filed by the parents, grandparents, or guardians in that successive order, remember the exclusive and successive order above set forth is to be followed. Neither of those in the succeeding classes can file the complaint if any of those in the preceding classes are present and not otherwise incapacitated. Okay? So nurun yun na siya. Either of the parents, remember, either of the parents can file the sworn statement, sworn written complaint. The father does not have that preference, and the complaint can be filed by the mother of the victim, especially where the father tacitly consented to the crime. Or where not one of those in the preceding classes can file or is otherwise incapacitated from filing the requisite sworn written statement, the grandparents can actually do so. Okay? So from parity of reasoning, either of the grandparents gihapon ang naay katungod nga mo file sa complaint. Okay? With respect to guardians, timan nga only legal or judicial guardians ra ang qualified to bring the action. Okay? In the people or in the case of People versus Formento, it was held that the complainant, having affirmed under oath that the fact that she was the legal guardian of the offended party, and such fact that not having been challenged, the sworn written complaint filed in said case was held sufficient to vest the court with jurisdiction. But where an aunt of the offended girl had not proven to the satisfaction of the court that she was the legal guardian of the latter, the sworn written complaint of the aunt was deemed insufficient to vest the court with jurisdiction over the case. So it has to be legal guardian or judicial guardian, meaning na siya authority from the court or he or she has been appointed by the court to be the guardian of that minor. Okay? Now, kung wala ning file ang private offended party, wala naka-file ang parents, grandparents, or guardian, kisa naman lang ang moprotektar sa katungod sa offended woman. It can be done by the state in the exercise of the right of parents patriae. When the offended party dies or becomes incapacitated before she could file the complaint, and it is no known parents, grandparents, or guardian. Okay? Now, remember that in prosecutions for adultery and concubinage, the person who can file the complaint, as what we have emphasized earlier, should be the offended spouse and nobody else. Okay? Corollary to such exclusive grant of power to the offended spouse, it necessarily follows that such initiator must have the status, the capacity, or legal representation to do so at the time of the filing of the complaint. I remember the case, no, kaning People versus Ibay Sumera. This is also one of the cases that I discussed in my persons and family relations. Kaning kasuha, ang bana diri sa babae kay alien, meaning foreigner. However, nakig-divorce na siya sa iyang ex-wife. Okay? Unya, nakakita man siya nga ning progress ang panginabuhi sa iyang ex-wife, ning kiha siya og kanini ang adultery against the ex-wife even after the divorce for allegedly daw ang iyang ex-wife na aday kabit. Okay? But the Supreme Court said in that case, where the alien complainant as a supposed aggrieved husband had obtained a valid divorce from the accused in this country before, or in his country before he filed a criminal complaint for adultery against the latter, such proceeding should be deemed or should be dismissed since he can no longer be considered as an offended spouse. For by this is meant that he is still married to the accused spouse and at the time of the filing of the complaint. It should be remembered nga kung mo file ka ana, ma-offended spouse ka kung married pa mo sa imuhang asawa or imong bana at the time of the filing of the complaint. In this case of Pilapil versus Ibay Sumera, divorce naman siya when the alien spouse or alien complainant filed the complaint for adultery against the ex-wife. All right, so also remember that. Now, okay, tiwason lang ni nato, okay? In previous cases on adultery, the distinction between consent and pardon by the offended spouse was not clear. Thus, in People versus Ginukod, the Supreme Court held that consent refers to the past commission of the offense. In the subsequent case of People versus Schickenberger, it was held that consent refers to future acts of adultery and pardon refers to past acts of adultery. In People versus Engel, the Supreme or the Court of Appeals adhered to Ginukod's doctrine. However, in the latter case of People versus Zapata, the Supreme Court reiterated the Schickenberger doctrine, wherein niingon dito nga kung consent refers to future acts, while pardon refers to past acts, okay? So remember, therefore, that the present rule then is that consent refers to future acts. Kung pardon refers to past acts of adultery. The importance of this distinction is that consent in order to absolve the accused from liability is sufficient, even if granted only to the offending spouse, whereas pardon must be extended to both the offenders. Okay? The pardon, however, contemplated in seduction, abduction, and acts of lasciviousness as specified in Article 344 of the Revised Penal Code must be expressed. Okay? But in concubinage and adultery, ang pardon pwede ra express or implied. It will suffice to bar a criminal prosecution. Okay? Unya, also, sumpay to sa Rule 110 Section 5 nga ang sworn statement is required, or a sworn written statement or complaint is required in both written and oral defamations imputing a crime which cannot be prosecuted de officio. Okay? Ang defamation nga gipasabot aning rule consists in the defamation of the offenses nga atong gihisgutan. Offenses sa adultery, concubinage, seduction, abduction, and acts of lasciviousness. So kung pakauwawan ka, gumikan kay kuno, nangabit ka, or nikocommit ka og seduction or abduction or acts of lasciviousness, that kind of defamation cannot be prosecuted de officio, okay? It has to be in a form of sworn written complaint filed by the offended party, okay? Now, the criminal action for defamation under this existing rule cannot be brought, cannot be brought at the instance of any person other than the offended party. The rule, as partially quoted, is clear. No criminal action for defamation which consists in the imputation of any of the offenses mentioned above shall be brought except at the instance of and upon complaint filed by the offended party. This rule clearly provides that only the offended party can initiate the criminal action. Okay? I think that's it for now. By Tuesday, we will continue our discussion on section 6, okay? Sufficiency of complaint or information. Now, after we finish Rule 110 as a way of determining if you have really understood Rule 110, I want you guys to, we will have an activity. We will have an assessment task in the form of a preparation of an information. And I will just post the mechanics later on. It will be a fun activity because after you draft your information, there will be peer feedback. Okay, you will be grouped into several groups, and then you will be tasked to prepare an information, and then the other group you will be crossed group also, and then you will have a peer feedback from the other groups. So that will be an exciting activity. That would be after we discuss Rule 110. All right. So thank you guys. See you on Tuesday.